Well, hello and welcome to another episode of the X-Files, the Divorce and Separation podcast for people going through family law situations in Australia, or who maybe just have an interest in what the law says about parenting and property and anything family law related. I'm Alex Wynn, I'm a family lawyer, and I am a co-host with my friend Liza Friedwald, another family lawyer for her sins.
Yes, hello everyone. Alex is right. This is not just for people going through the process. It can be used for people who are trying to support others going through the process, or it can also be used for insomnia.
That's right. And if you ever get caught late at night and there aren't any football matches on, well, obviously that's a tragedy. But then the next thing you can do is to listen to the X-Files podcast.
Yeah.
Can I just preface this like I do all the time and say, this is just you and I having a conversation. This is information only at best. It's not legal advice. If you're going through the ringer or you know somebody who is, reach out to us and we'll be able to help you professionally. If you have your own existing lawyer, go and see them. Get legal advice from somebody qualified to do that. Professor Google is sometimes not your friend, and ChatGPT is definitely not your friend. Okay, so that disclaimer out the way. Information only, not
Yep.
advice. Today, we've got an intriguing topic, which is what judges really think about in parenting cases.
They look for. What are they looking for when they see you coming and you've got all your complaints about your ex, how they're such a bad parent? What are they really looking at?
We can kind of move to rocket speed here. We've gone to the end of our case. We're in our trial. They're reading affidavits, the big ones that you've written or your lawyers have written, and they're listening to the cross-examination. So what are they listening for?
Whatever it is that you think they're looking for, chances are it's not what the judge is looking for. Okay? I think that's the very first thing to realize. What matters to you doesn't always matter to the judge. The judge doesn't particularly care whether the kids have Maccas for dinner every night. The judge doesn't care whether or not they're allowed to use their iPads before bed. They don't care how their hair is cut. But what they do care about are things like safety, and that there is an opportunity where it's safe to do so for that child or children to have a meaningful relationship with both parents. That's the number one crucial thing that the courts are looking for. If I could sum it up in a lift statement and say that's what the courts are wanting to know. Are the kids safe? And is this arrangement going to promote their best interests?
Yeah. There's a third thing for me that I think also, whatever aspirations you or your ex might have, are the arrangements practical?
Yeah.
You know, somebody who is, dare I say, working away a lot of the time, it can be very difficult for that parent to have equal shared time with the kids because that does not work on a practical level. So it's safety and it's practicality and that other great thing that you just said. Sorry, I'm shy on my caffeine today. I need a cup of tea.
It's all fine. The funny thing about doing these podcasts when we're on video is that from time to time, anyone who gets to know Alex gets to realize that Alex is very knowledgeable and he knows a lot about the law, a lot about the history, and does like to talk. So there are plenty of times where I have to catch myself just going, oh, here we go. And Alex will probably do the same because we've worked together for so long now that we do get a sense of, we know exactly what the other person's thinking, and we sort of skip ahead. But bringing
Me
it
too.
back to what we're here for today, we are looking at the big picture here. Okay.
Yeah,
The very first thing we need to talk about is, in terms of parenting matters, is let's look at the big picture. And when I say that, I'm talking about, it's not an automatic 50-50 equal shared time. It's one of the many options that's going to happen as a result, but it's definitely not the starting point. And I think that's one of the common misconceptions by people, and particularly parents, that they just assume that they're going to be entitled to equal time. And as you rightly pointed out, if there are circumstances that render that arrangement very difficult or impractical, then you're not going to be able to facilitate that time in that way, and the court's not going to make such an order. So,
Yeah.
you might have someone who's wanting to fly up interstate every few days or something. The court's going to see that that's simply an aspirational order.
It's
It's
not
not,
sustainable in the long
it's
term,
not
is it?
sustainable. And there's no point having those orders that are aspirational in place and not sustainable, because again, and like I say all the time, is look at it from the perspective of your kids. Your kid's going to be excited. Dad's coming back every couple of days or every weekend or whatever the case may be. And things are going to happen to dad in dad's life. Work will happen. Illness will happen. Flights change. Things like that. And there'll be disappointment after disappointment. And it's just simply aspirational, and it's not in the kid's best interest.
It's setting the kid up to fail psychologically at the very
Yeah,
least,
it's just
isn't
not
it?
nice.
And look, so rolling it back is to make sure that what you're asking for is workable. And you should be mindful as well. Don't ignore the other person in the courtroom. They're your kid's parent as well.
Yeah.
Think about what their situation is too when you're framing your orders. If you're both, you can both either work from home or you have jobs that are very flexible and you're near each other and there's no risks of harm, then sure. I mean, it could well be that an equal kind of shared care arrangement would work. But if that's not your reality, or if the kids have got a particular need or something that one parent is better placed to look after because of, say, work commitments, you've got to be realistic about that. And the judges are going to, it's a really tough job to be a judge and to make difficult parenting decisions. So they will be guided by always, I mean, the paramountcy principle in all parenting matters is the best interest of the child. We hear that a lot. It's written in the legislation a lot. It means something different in almost every case. It's very nuanced.
There's no set formula about what that means and what that looks like. And for some people, it will mean needing both parents. But in other cases, it might mean the best interest is to have no time with one of the parents.
Yeah. I mean, there is a long list of considerations in the Family Law Act, which is this great big behemoth of legislation that we work through. So it's all written down in the part dealing with children. You can find there's the definition. But within all of that is the any other considerations component. So
That's right.
in other words, your situation is going to be different to to your friend's situation, to the person you met in the pub or in the hairdressers. So don't rely upon that. Don't rely upon Google. Think about your own situation and what works best for your kids for their sake, not yours, I'm sorry to say.
Another issue is it's not about scoring points against the other party. So it's definitely not in terms of who's been the better parent. The court's not that interested. That was you. Yeah, it was me.
Well, it was also Siri as well. She was.
Yeah, I
She
think
did
in my
most of
case
it.
it was a combined effort, but I do know in the early stages I was not on night duty because I'm not a night person. So yeah, I was lucky. But in terms of those types of arrangements,
They disappear though, don't they? You're
they
right.
do.
You don't get merit badges like you used to do in Cub Scouts or whatever. Nobody's giving you, a silver arrow for doing all of the nappies, over this
No.
3-month period. Or
There's no thank you, congratulations, you're a great parent or anything like that. In fact, it's the opposite. It's a lot of scrutiny to go through parenting proceedings. You have some people have to go through drug testing and alcohol testing and liver testing. God.
And we won't talk about that. Moving swiftly. This is honestly, it's tea in this cup. I
Yeah,
promise.
I was just going to say, what time of day is it, Alex? Really? What was
It's
it
still
really?
morning. It's still tea.
Yeah, okay,
It's not
fair
1
enough.
o'clock yet. You're right, though, and some people have to deal with lots of untoward allegations as well. There might be sexual abuse allegations, there might be physical abuse allegations, there might be psychological abuse allegations, there might be allegations of coercive control, there might be any number of, we've seen it, I think, all, whatever somebody can be accused of, we've seen them be accused of in the family law arena.
Well, didn't
And
they say
have
that
to deal with it.
91% of cases, I don't even know where I got that stat from, but anyway, probably made it up.
73% of all statistics are made up.
Well, here you go. Here's another one. 91% of cases involve some allegation of risk.
I
And
think that was in the those stats were probably pulled from last year's court report. They
Okay.
do a
Right.
report each
So it
year,
is,
but
there is something
you're
to
right.
it.
87% was the last one I read, but wow, it's up to 91. It's incredible.
Yes. Well, I know from my own caseload. I look at every single one of my parenting matters. I don't think there's one case, there might be one, where a party says, "I know that we don't have any risk issues. There's no violence.
Mm.
There's no issues about abuse or history of abuse." Everything these days has some element of that. And
Mm.
I'm not here to judge. I'm not here to say whether it's true or not true. It could be someone's perception as to what's happened, because hindsight's a wonderful thing, especially when you break up with someone.
Yeah,
You
and you're
know,
raw
what
with
your
the
thoughts
emotion.
are.
Do you know, I do wonder, because we talked in a previous episode about the central practice direction and all the array of forms that you have to fill in these days. Now, one of the forms that you fill in a parenting case is called a notice of risk. Well, it's a slightly longer word than that, but let's call it a notice of risk.
Yeah.
And I I do wonder sometimes when you see that it's a long form and it's quite tautologous, it repeats itself a lot, and the temptation to put an X in the yes box, saying, "Does your ex, abuse alcohol?" Or and
Yeah.
sometimes you go, "You know what? Yeah."
Yeah.
And then that goes into that 91%, and it
He
can
didn't he
create a
didn't
false
return their
narrative.
shoes properly on the weekend, so yeah, he did.
Yeah, so they'd have gone to school barefoot. That's
Yeah,
child abuse.
totally.
And this is the level of sometimes pettiness that deflects from the real serious situations that do need to be addressed. But yeah, I mean, one of the things a judge is going to be looking at, coming back to our question for today, is what are the elements of risk? Is there genuinely a problem with the children spending time with one of the parents? Is there a way of managing that risk? Does that time always have to be supervised, for example? And that doesn't always mean physical abuse. We've seen cases in recent times, reported cases too, where one parent has alienated, I know the courts don't like to use that expression, but has ostracized the child so much from the other parent that the only way to resolve that and to restore that relationship is to take the child away
Yeah.
from the parent that's had the care of the child completely, and then only see that relationship restored on a short-term supervised basis
That
because of the
kills me.
harm that
That
they've
really
done.
does. I hate those cases.
What about things that they would look to and reward? I'm thinking more about what sort of child-focused behaviour
Yeah.
would
So I
would
think,
stick out as being in your favour or in favour of your case.
well, the first thing that I like to make sure that my clients do is facilitate time,
Yeah,
encourage that relationship. Don't badmouth your parent. Don't ask them questions, but also
don't withhold the
don't,
kids.
but don't withhold the kid, but don't make them have to keep secrets. I
Yeah,
see this all the time, and it's in orders, and it annoys me to no end. And people write in there that the other parents not to interrogate the child, which then it gets translated into you're not allowed to talk about anything that you do with the other parent. And then you get little Johnny coming back to mum saying, "Oh, dad said I can't talk to you about these things." So the fact that little Johnny knows what he can and can't say to either one of his parents who are meant to love him dearly, like, Jesus, just get on with it and just let them tell them that they had a great time and they had pancakes and ice cream for dinner, even though they shouldn't be having ice cream and sprinkles at dinner time. But still, they had it and they
people
enjoyed
people
it.
will
And
try
it's
and put that in
one thing.
affidavits, won't they? Oh, they eat all the wrong food at
Yeah,
dad's place. They go out for pizza, and
you
really.
know, it should be a case of that would have been delicious. I bet you enjoyed it. Not, oh, and what else did they do? And,
Mm.
you're not to tell him. You can have this, but you're not to tell him what we do.
Or making those sort of
Yes.
almost accidental remarks. You go, "Well, that's not very healthy, is it?" And those little messages going in, and they'll at some point it'll come out and it'll come blurted out to maybe a family report
Oh,
writer,
kids are
maybe a
sponges.
child court expert.
Kids
But,
are sponges and they will leak all that information at the wrong time.
and not only that, it's a big burden for a little person to
Totally.
carry around because they're
Yep.
caught in the middle of that. So be child focused, be open but non inquisitive. You sort of have to say, have an organic relationship with the other parent where you can. Let the child have a perfectly natural relationship. They don't need to come home and be drilled about what's gone on.
It shouldn't be a scoring match,
No.
Oh, I've got some orders here. Little Johnny's great grandmother is turning 100 on the weekend. I know it's your time. Do you think that we could just change these orders so that he can come to his great grandmother's party? No, it's my time.
No, don't do that.
Think about it from the perspective of what's little Johnny missing out on? Little Johnny's missing out on going to someone's 100th birthday party. Is this really going to affect you? How is this actually affecting the child? Think about those things, and that's how you become child-focused. It's all very well and good. I hear people go, oh, I'm making these child-focused decisions, and they're not being child-focused at all. They say they're being child-focused, but they're not. You're only being child-focused is when you actually get into that mindset of your kid. And I'm not saying that their views is 100% is taken, because I'll tell you what, if I was using that example, my kids would be on their iPads all the time eating chicken nuggets for dinner, and that would be the definition of child focus. But it's not. It's about having that common sense and looking at it from their perspective, saying, how's it affecting them? Am I getting that good relationship? Am I being denied milestone events, things like birthdays, anniversary things?
Don't be petty. It's not about you getting revenge on your ex by withholding or refusing those perfectly reasonable requests to ameliorate conditions. Remember, most court orders are written with those magical little expressions in them saying, unless otherwise agreed between the parents. Or when lawyers are doing, unless otherwise agreed in writing. So that there's no ambiguity there. So you can always flex these arrangements. If you and your ex can do that for the sake of your kid, you don't have to like each other. You can grit your teeth every time you talk to them. That's fine, but smile sweetly on the outside. Cooperate. That's what your children need. And if you are in that final hearing that we talked about, if in your evidence you can show a pattern of you cooperating, I mean, cooperation is a short leap then to co-parenting, isn't it? And so you're saying, look, we can get on for the sake of our children. We can do this. Therefore, these orders are appropriate. And looking at patterns of where you have taken the kids to school, you've engaged with, their teachers, and you've done the parent-teacher interviews. Heaven forfend that I do. Just be the parent. Don't just leave it to the other person all the time. You should know who your kids' doctors are and dentists. You should know what the treatments are. You should know if they're struggling at school. Those are the things that a judge will be going, okay, well, you're mindful of. It's pretty apparent that you know what's going on in your kid's life. That's really important. It's not just about being, well, I take them to football and that's what they love. And they go, well, what else do they like? What do they not like? Make the court understand that you get your kids and that you're genuinely concerned for them, rather than they don't know what they're doing and using it as a critique of your ex. That doesn't work. I think
that's a really good point, because that brings me to that issue of credibility. And when we say credibility, we don't necessarily mean whether you're a liar or not a liar, because we're all liars at the end of the day. It's just the
that's what Mickey Haller says, isn't it? Everybody lies.
It's just the level that we lie at. So in terms of credibility, what we're looking at there is consistency in terms of whether that evidence fits with what has been reported. So you might say in your affidavit, I've got a really good relationship with my child, but then as Alex pointed out, what does your child actually like to do? Well, how are they going in school? I'm not too sure. When was the last time they went to the doctor? I don't know. What's their favourite food? I don't know. Chicken nuggets. You need to have that consistency in your evidence between what is actually happening.
And hopefully it genuinely reflects your engagement with your kid.
And that's right. And so that's a big thing to look at. There are a couple of little traps that I find that happen, particularly in cases where there's allegations involving risk. Sometimes you'll get a case where the parent will allege that the other party is unsafe, they're unfit. Drinking's an easy one to give the example of. And they'll say, they need to be supervised. There needs to be supervision. But yet you'll find that there's a whole history of weekends and weeks and holidays where that parent has left the children in the care of that so-called drinker. And why now is the drinking such a problem? And so courts are usually cottoning onto those sorts of things, and they go, hang on a minute, it was okay for you back then. Why is it not okay for you now? And I'm not saying it's okay to put your kids in the care of a drunk, But the point is that you need to be consistent and not embellish what that history was.
So
For
it's
example.
really about being a little bit more truthful, perhaps,
Yeah.
avoiding exaggeration. And as you say, I mean, if somebody's got a history of looking after the kids without any incident,
Mm.
then for you to turn around then when it gets to a pointy part in the court, say, but they must be supervised from now on, that doesn't stack up. That doesn't look credible. It
No.
makes you look as though you're absorbed with anger to the
Yeah.
parent, to the other adult, instead of thinking about, oh yeah, actually they are fine with the kids. They do look after them pretty well,
Yeah.
which should take you to a different place in terms of an outcome. Risk is a really hard thing to gauge. It's probably the biggest thing that courts have to weigh up in the current crop of parenting cases that we're seeing. What is a real risk? You've got, as I said, there was that case not very long ago that was reported, and I think we're both aware of, about one parent who had effectively alienated the child from the other parent to such a degree that the only way to resolve it was to remove that child from the parent with whom they were so connected and put them with the other parent, because that abuse was going to continue on, that psychological abuse, and it would have led them into an adult relationship of zero with the other parent. And that was all to do with the one-sidedness of information. So be careful, be really careful about not making the other person seem like some really draconian monster when they're not. By all means, if there are behaviours that could put the children at risk, that goes into the material, that's relevant. But don't necessarily think of them in the worst capacity of all times. The judge isn't going to do that. The judge will be making an assessment as to where the risks really lie.
And it may not be a risk case after all. And it may, in
No,
fact, be more of a best interest, or it may be more so that it's the risk there. They might be a monster. They might be a monster to you. There may be a power imbalance between you and that other party. And in that case, it may be that the two of you are unable to co-parent effectively, and it may be that you might need to have sole decision making or over particular issues because there's that inability to work together. Because it's not just about the time that you have with the child, it's also about who makes decisions for the child. And we no longer have this presumption of joint decision making, joint parental responsibility as we used to call
as
it.
it used to be, yes.
So that's all gone by the wayside. So we've got to start thinking about how are these decisions going to be made. And if the two of you cannot communicate, then how are you going to make decisions jointly together? If you hate each other's guts that much that you don't trust each other, that you can't put your own grievances aside for the sake of your child, how do you think you are going to be able to communicate enough to be able to work out things like serious medical decisions or educational decisions? If you can't put your own needs aside for the benefit of your child, then are you the right person to be making decisions for your child? That's the
No.
question I have.
And I think what we're seeing more and more of now is decision making responsibility, if I can call it that for now. They just got decision making now. But
I know.
yeah,
I
sole
call it everything.
decision. I know
I'll change it again soon. It's okay.
it's bastardizing the English language.
Yeah.
But there you go. You put too many lawyers in a room and get them to draft things. God help you.
Yeah.
So when we're talking about decision making, if you can't communicate, I'm seeing more of a trend of courts saying, that's fine. For these discrete areas, this parent will make those decisions. And sure, you'll put in there a consultative process. So it might look something like, mum makes the decisions about schools and medicals, for example. But if there's anything major changing, she'll say, this needs to happen. I need to make a decision about this. This is what I'm thinking. What do you think? And the other parent gets the opportunity to put their input in. And that'll have to be considered, but it's not going to bind the parent. So having some kind of consultation just to make sure that that non-decision making parent has a say, but it's not a determinative say. It just helps the matter move forward, because you can't be locked in forever going around in circles, mediating over, right, little Johnny's going to high school, which high school? And well, I want him to go to this one and you want him to go to that one. That has to end. You have to bring the cycle of litigation to an end at some point.
Yep.
And that's sometimes the only way to do it, is just use the awful expression, rip the Band-Aid off and give decision-making responsibility to one parent.
That's right. That's some of the negatives, but some of the good stuff that you can lead and what the courts do like, they like those independent third-party observations. So your school report cards, the
Yeah,
kids' school report cards, not yours, obviously. They might be a bit old. So you've got your school records, medical records, because if there are issues about risk and concerns about mental health, a lot of the time that's all been reported into your GP or to a psychologist or counsellor. Family reports, drug tests, if you have to go through those sorts of things, just be careful. I am very skeptical about what we get in terms of a document. There was a warning sent around to family lawyers recently about the doctoring of drug test results,
incredible.
using AI to do so. So it is getting a bit tricky out there in terms of being able to verify that that is like legit. So sometimes the better thing to do will be to issue subpoenas so it comes from that entity.
Yeah, directly from the source rather than through somebody who might have an interest in manipulating the information.
And so anything that's corroborated in terms of your evidence, if there's a message, there may be some accusations or there may be some allegations of violence involved, and there may be an admission by one party to say that they did in fact do that thing, and they've said, I'm so sorry I did this. You produce that document and you don't need to worry so much about going into the he said, she says, and will we be believed and all that sort of stuff, because it's quite clear. Police records, sometimes there'll be subpoenas or information sharing records from the police, and they will have
and the Department of
interviews.
Child Safety in your state
Child
as well.
safety, yes. So all those things, they will all produce a lot more what the court considers credible evidence rather than what you say. It's not that the court doesn't believe you, it's just that the third party...
But they might not believe you.
Yeah,
If you've been over elaborate in your evidence, perhaps it's harder to believe somebody like that.
Yeah.
Of course, the elephant in the room that we haven't talked about is a big piece of evidence in many contested parenting cases is the family report.
Yeah.
Now, this is a short podcast, not designed to go into the ins and the whys and the wherefores of family reports generally. But suffice to say, that's an expert report that's prepared by somebody who meets the family, who meets the children, who meets the parents and their significant others and significant people in the kids' lives, reads the documents, reads the material, sees everybody, interacts with them, observes them, and then they write a detailed report. Now, these are usually people with social science backgrounds or psychology backgrounds, typically, and they're appointed by the Attorney General's office as being appropriate to write these reports, which are very lengthy reports, most cases.
They're used, unfortunately, as a bit of a weapon in a lot of cases to pressure a party into complying with and adopting a particular position. I'm not a huge fan of many family reports, and I know that they can be useful, but I think they're overused, and I think that their utility is exaggerated.
It's a troublesome thing because sometimes it's the only neutral piece of evidence that a judge has before them. And so it's better that than zero neutral evidence.
I get that, but how can you actually form that opinion after one consultation, like 10 minutes with a child who doesn't know you?
Yeah.
There's a reason why you need multiple sessions, and I realise that the process needs to be capped, it needs to be streamlined, but I really do worry when there's so much emphasis put in terms of the findings in that family report, because it can really devastate a family.
Yeah.
You get a bad report, you're stuffed.
It's rare, isn't it, that you'll see a family report and when you're talking to your client about it, that the client go, well, they've got everything right. They've recorded all of that correctly. There's no mistakes in there. And I see what they've done. I understand.
Yeah.
Often there's a lot of small but significant, if you're the person about whom it's been written, mistakes about some of the factual matrices.
Yep.
Or, they seem to have very early on formed a view that this parent is the superior parent, or there could be any number of reasons. But they're a very imperfect process. And, famously, there's an old case that says there's no magic in a family report, and yet they're highly persuasive pieces of evidence. So if you're going to go through the ring and you are about to go into a family report process, you should probably reach out and get some guidance about how do you best prepare for a family
Who
report.
to pick.
Well, it's a state of affairs, isn't it?
Unfortunately, and this may be a bit controversial, but there are some report writers you want to run for the hills from. They should not be report writers. They say the most outrageous of things and they can get away with it. They're not accountable to anyone.
Some of these family reports cost many,
Thousands,
many thousands.
thousands of dollars. They're so
I,
expensive.
they can range anywhere from, you know, 5, 6 to 25, 26 kind of
Oh,
thousands of
yeah.
dollars, and beyond that. And then if you sprinkle in allegations of psychiatric illnesses, then people are being psychiatrically evaluated as well. And again, that's a little snapshot. You look at a person for a little while as a psychiatrist, you form views and you write reports that will be forensically used against that person for decades. It's amazing.
What I'd like to see happen with family reports is that I would like it, like some of the personal injury matters, for example, some of those reports. The consultation is recorded. There is a transcript that is attached at the end of the report, and you can then see what was actually said versus what was not said. And if there is a matter that was reported or recorded incorrectly, well, it's quite obvious that was what was said, as opposed to, oh, I didn't say this. Well, yeah, you did. It's right
Yeah.
here, you know?
And of course, we are increasingly living in a world where people are recording everything
No
anyway.
reason why it couldn't be done. That's all I'm
Plus,
saying. I think it would allay a lot of people's concerns, because you get your client, they go off to the family report, they come back and then they say, oh, well, this guy just said to me that if it's not physical abuse, then it doesn't count as domestic violence. What do I believe there? I want to believe my client.
not only that, but if a family report writer does say something like that, which might be controversial at the beginning of the interview process, then how does that impinge upon how you behave in that interview afterwards? If you think nothing I've said in my material is being believed by this person, they think I'm a liar from the get-go, and so you become more withdrawn, you become less engaged in that process, you trust it a lot less, and that can then come through with the findings against you. Or they're mistrustful, they're evasive, and family reports are such a linchpin in parenting cases, and you're right, there's so many issues with them. I mean, it is the only thing we have, as I say, from a purely neutral perspective, but sometimes we can see agendas in those. And that's not to impugn any particular report writers, and there are some great ones out there, I would say as well.
I wouldn't be very comfortable going through
Yeah.
that process knowing that someone has only spoken to me for 45 minutes and then they report and make those sorts of comments. And fortunately, you get some judges, though, who will completely accept that. But then there are plenty that will just go, oh, well, the family report writer says this, particularly at an interim stage. It can be damning.
It can be, but it can also illustrate the way in which the judge is thinking about a case.
Yep.
So we have to be very mindful of what's in those. And the other person, of course, that the children ought to meet these days is the independent children's lawyer, where there's one appointed. So ICLs, that's independent children's lawyers, get appointed in some cases, not all cases. And very often now, particularly when the kids are school age, the ICLs will meet with the children.
Yep.
Not very much. And despite some specialized ICL training, ultimately it's just a lawyer talking to children and then feeding back some of that information through to the judge. And again, I'm concerned
It's better
about
that I say nothing on that point.
how little time and deep thought goes into those interactions and how often they are.
I don't understand, though, why the ICL doesn't have to meet them twice. Once in the care of one parent, once in the care of the other parent, because depending on whose care those kids are in when they meet the ICL, and a lot of the time it's done on Teams and video, and you might have mum or dad hovering in the other room, even though they're not meant to be in the same room. They're still outside listening, wording them up.
I do know some ICLs, I'm thinking of one in particular, who makes a special effort to see the children brought in by one parent and then another occasion brought in by another. And that's great. And that works terrifically well to give them a balanced insight.
Yeah, I think it's probably a matter of resourcing and whatever else, but still,
Yeah.
a lot of focus and weight is given to the ICL's views in parenting matters. Often,
Mm,
despite you being the applicant, the court will say, righto, Mr. or Mrs. ICL, what do we have here? They want to know from the ICL.
they
They
do.
don't necessarily want to know from the parties just yet. They want to know what's going on, who's doing what and when, and why is this happening, and what troubles are you having with getting information from either party.
Yeah. I'm not convinced about the process as being the best one that we could have. But again, I don't want to impugn any
No,
ICLs who are generally very hard-working, dedicated people.
that's right.
Maybe don't have enough time.
It's always comes down to resourcing issues. That's
There's
basically
no perfect case,
no.
but I guess maybe this conversation about parenting cases probably gives you an idea as to the kind of problems that judges have. And
Yeah.
so to give yourself the best opportunity to get the orders that you're seeking, I'm assuming that you've gone through the process. Am I seeking something that's practical, reasonable, and appropriate for the kids? And if you are, then be the parent that has been engaged. You may not agree with things that the report writers say or the ICL say, but think about those. Think about what your response to those might be as well. Be the sensible one. Be the one that knows what's going on at school. Be the one that knows, what medical issues maybe the kids have. But be non-aggressive towards the other person at all times. Of course, it doesn't help you. It just continues that litigation beyond the court case.
And it's not about your rights as a
No.
parent. I say it time and time again. As a parent, you don't have rights. Your children have the rights.
Yeah,
You
you
need
have
to adapt to
responsibilities.
suit
Yeah,
the interests and the needs of your children, not the other way around. They are kids. Let them be kids. Keep them shielded from the conflict as much as you possibly can. And doing things like micromanaging the other household, that's not going to work in your favour. Sometimes you have to let the other party make those mistakes, make parenting
yeah,
mistakes. As I said, let them have their ice cream for dinner from time to time. But then
yeah.
come back and explain to them how that's a bit of fun and that they'll have good memories about that.
You have to let it go.
You do. And the moment that a court sees that you're weaponizing or using the kids to try and fight your battles and to position yourself to get back at the other party, it's all going downhill for you.
Yeah,
So focus on that specific evidence, what you actually think is relevant. If you don't know what's relevant, get some legal advice. When that legal advice comes through, limit your case. Don't sit there and argue with your lawyer about, I need to include this. This needs to go into my affidavit. It probably doesn't.
no, you're probably going to get the judge on the wrong side if you start rehearsing arguments from a decade ago that have nothing to do with the decisions to be made. They just show that you're unable to let go of some things, risk of letting go again. So it's being pragmatic, it's being rational, it's being reasonable, and it's making sure that your evidence is all of those things. Wow. And there's no right answer to this, of course. It's
No.
what your children need are going to be very different to the next case that comes through the judge's door. So, look, I hope that helps. There's a lot to unpack in talking about parenting cases, and we've only scratched the surface there. If you are listening to this or watching this and you've got some issues that are going on with your case, reach out to me, reach out to Liza. But remember, this is just information. It's not legal advice at this. And this is just our podcast, just to share a little of our thoughts.
Don't forget to like and subscribe to
Oh,
our
yes,
YouTube
please. That'd
channel.
be nice. On
Yeah,
YouTube. Hooray, we're out there in the world.
we are out there in the world.
Thanks,
Excellent.
everybody.
Thank you.
Thanks, Liza. See you.
Thanks. Yeah, bye.